Yes, everyone is, you are audible. You can go ahead.
Okay. Dear friends, I welcome you all in joining this webinar. This is the first webinar organized by me, and I intend to organize more webinars in the coming days by various persons of concerning various fields. The topic of the day is freedom of press, which is to be addressed by Senior Counsel Mr. Masilamani, sir. Sir, I sincerely thank you for accepting our request. I am ever grateful for that, sir. I also take this opportunity to thank my family, my office colleagues, the IT team, and D-Crafts who are instrumental for this and who all extended support in this, sir. Sir, please commence the lecture, sir.
Yes. Good evening to the organizers of the seminar and to those friends who are listening to this inaugural speech of the seminar. Sri J. Ravindran and M. Snega advocates and their host of juniors have organized this seminar on an important subject. I congratulate them for their initiative to organize and to continue the seminar in the public interest. I wish the seminar, yes, discussions, many more current topics, and create public awareness on the chosen subjects. Knowledge is wealth, knowledge is strength. I wish their endeavor every success. I thank J. Ravindran Law Office for giving me this opportunity to speak to you. The topic of this evening is the freedom of press. It is a big ocean. I shall try to pick up some pearls from underneath and place it before you for your view. Due to COVID-19, I am handicapped since I do not have the services of a typist. Hence, I am going to use my handwritten notes, which may have hiccups here and there. Please excuse me for saying. The topic, the freedom of press, is a very big topic. And I am only going to give you an overview of this subject today. I have subdivided the subject into various divisions. The first one is its origin of printing and next is recognition of the freedom of speech. The third one is the importance of the freedom of speech. And the fourth one is the importance of the freedom of press, the concept of free press and the regulations, the emergency, the Indian press, the media now, and the high and low of the free Indian press today. The origin started in China, further developed in Europe in the 15th century, which revolutionized the dissemination of information at a time to a larger section of the society. Originally, wood block was made in China and pressing the wood block on a parchment paper, and then they made a print out of it, and which was the first printing. Further, the printing was developed 1040 AD. A German by name Johannes Gutenberg developed the printing press in the 15th century. The first newspaper called Account of All Distinguished and Commemorable News in Germany in 1605. The second heading would be the recognition of the freedom of speech. In 1789, French Declaration of Right of Man was made, declaring free communication of thought and ideas is one of the most precious rights of the man. of course, subject to the responsibility for the abuse and the liability for such an abuse. After the French, the Americans, the first amendment to the American Constitution came into being in 1791. Congress shall make no law, the Congress shall make no law abridging the freedom of speech or press, abridging the freedom of press. That was a recognition of the press and the freedom of speech. The American Constitution's objective are men are born equal, they shall have the right to liberty and pursuit of happiness. And the word liberty found in the American Constitution is not only physical, but also mental, but also intellectual. Such an intellectual liberty is being granted in American Constitution, and the objective of the American Constitution, it has developed to a great extent, and it has helped the world democracies to develop the idea of liberty, and not only a physical liberty, but also an intellectual liberty as well. So far as India is concerned, Article 19(1)(a) of our Constitution protects the freedom of speech and expression as one of its fundamental rights. Even though the freedom of press is not specifically mentioned in 19(1)(a), the freedom of speech and expression found in Article 19(1)(a) of the Indian Constitution has been considered to include the absolute freedom of press as well. Of course, subject to Article 19(2), where restrictions are provided for reasonable restrictions to be imposed. I will deal with the reasonable restriction much later. Freedom of speech has been well recognized, and it has been expression in many places. In Bridges versus California, Frankfurter J, in his dissenting judgment,
law is very
Frankfurter J, in his dissenting judgment, observed freedom of speech and of the press are essential to the enlightenment of the free people and restraining those who wield power. Unless those persons who are wielding power are restrained, reasonably restrained, the power that is being exercised by the authorities will become untraveled and may result in the abuse of the same. Freedom of expression of citizens shall include the freedom of receiving information from any source without interference from the public authority. Free press is the primary source from which the information is obtained by the public. Freedom of press forecloses the state from assuming the guardianship and the tutelage of the public mind. If there is no freedom of press, the authorities who may wield power may try to assume the guardianship of the mind of the ruled, and they will try to tutelage to follow the particular line of those which will ultimately undo the freedom of thought, freedom of views, and freedom of knowledge, which is the very basis of a human right and which is the very basis of a democratic setup. Free press and free state are inseparable. Free press and free state are inseparable from each other. Without free press, there cannot be a free state. There cannot be a free state without a free press. Blackstone mentioned it. Liberty of the press is essential for the governance. Liberty of the press is essential for the proper governance. The only plausible argument against the press is to restrain it from daily abuse from the freedom of press against the state. Abuse of the freedom of press will result in suitable restraint and punishment under the general law of the land. Press regulatory laws, since no right can exist with unbridled liberty. Now there are so many laws governing the freedom of press. Now I would, in the statute book, there are very many laws which are there, and I shall give the list of it a little later. The most important functions of the free press is to expose the abuse of the power and the corruption of the public officials, which an individual cannot do effectively due to the personal peril of attack. The legally protected institution, namely the free press alone, can undertake this essential responsibility to protect the people's right, liberty, and personal freedom, and the proper functioning of democracy. Free press is a safeguard against the absolutism of public authority, whimsical rule, and oppression of the dissent and opposition. Suppression of opposition lead to an authoritarian government, and which is the antithesis of democracy. Next is, what is the meaning of the free press? Free press means printing without a previous license. Free press means printing and publishing and circulating without a previous license. Only, of course, subject to the law in force, and regulations are there to regulate the press. Pre-censorship of the press shall undo the press, undo the freedom. There is a basic concept whether there shall be pre-restraint or a subsequent judicial scrutiny and punishment for the wrong done. Prior restraint or prior intervention or censorship is on the free press, and such kind of a censorship or fetters would naturally be subject to the satisfaction of the administrative authority in power on the day. Administrative authority, when they are going to censure or going to proscribe materials from the press, and it will result in distortions of information in the society, which ultimately make the mind of the people in a wrong directions. Therefore, it is absolutely essential there shall be no pre-censorship of press. Press is nothing like a human being, like a man or a woman who is a citizen of this country. I don't need any permission or license to speak flows from 91A of the Constitution. Of course, I may speak wrong things. Of course, I may speak offensive things. Of course, I may speak defamatory things. Of course, I may even kindle the crime in the mind of the people because it is likely to happen. That doesn't mean the freedom of speech is suppressed and it should be trammeled. And that is why, like a human being, like a citizen, the press should not also be subject to pre-censorship or pre-review of the material to be published, which will almost equal to making everyone to control and to make speak after giving the text of their speech. Even today, I am addressing this seminar. I have not got the permission from anybody. I have only been invited to speak. I speak what I feel. I speak what I understand. I speak what I have read. And therefore, it is my right to speak. If I say anything wrong, which is offensive for under the law for the time in force, of course I can be proceeded with. Similarly, a press also cannot have a pre-censorship. Pre-censorship is anathema to the free press and which cannot be tempted. Of course, once a press publishes a material, it is subject to scrutiny of all the people. If the government or those people who are to enforce law find the publication is offensive and any law for the time being in force, they can proceed against them in a court of law, and the judicial scrutiny could always take place to find out whether anything wrong has been done or not. If the government proceeds against the press, of course the press has got the liberty to go to the judiciary to vindicate their right. What they have expressed is not offensive in accordance with any law for the time being in force. Not only the offense, but also the press cannot invade into the right of privacy. Right of privacy has been considered as one of the facets of fundamental right under Article 21 in the recent judgment. Till then, the fundamental right. There were a lot of discussions in various courts of the Supreme Court as well as High Court. Where do you find the right of privacy? Under what provision of law it is getting protected? The reason Puttaswamy's case, the Supreme Court has very clearly held the right of privacy is a fundamental right governed under Article 21 of the Constitution. It is a formidable judgment, gives enormous privacy to an individual from being invaded either by another individual or by the state or by the press. Similarly, defamation is one other subject which quite often is put against the press because the press is invading the personal liberty and the personal integrity and the personal honesty, personal good name and the public good name of the person. That is by itself is a very big subject, and I can only show the outer line of what is defamatory exercise of expression by the newspapers. The next one would be the concept of free press and its regulation. The concept of free press has been developed for a long time, and then the concept has to be recognized everywhere. Otherwise, there cannot be a free press at all. A basic thing of a free press, the essence of the democracy, free functioning of a constitutional institutions. Without a free press, there cannot be a constitutional free press. Now, what are the areas whereunder the press is sought to be interfered with by the state? If a number of ways they may interfere, and the press also may try to interfere in various ways. And that is a matter of great concern, and that has to be understood. I would like to bring to your notice one important factor, that the state from time and again would like to interfere. The state would time and again would like to interfere and control the press by various means. And Some of the means are the press is not immune from any law. But however, the state cannot make law in such a way that it will interfere with the freedom of the press. The areas in which the laws are regulated and which are governing the press are the ordinary form of taxation, the application of the general law relating to the industrial relations, the regulations and conditions of service of employees, the laws relating to defamation or contempt of court, the laws of trespass, nuisance, as regards the entry by newspaper men into private property and the right of privacy, and the liability for unfair reporting, and also regulation of a commercial activities of the press without interfering with its freedom of expression. These are all the areas of law and controlling the press. But these laws have to be made in such a fashion by the state which will not interfere with the freedom of the press. If the laws are made in such a way, if the freedom of the press is lost, then the free press and the free democracy shall be a farce. Similarly, Indian Penal Code contains enormous provisions for wrong done by an individual. Same thing applies to the press also. I will give you the details of those things a little later. As I have stated earlier, the press is not above law. Press cannot be above law. Press is also subject to general law. Press is subject to the general law of the land. The law of the press would also include the law of the person. If whatever the person is subject to law, the same thing is applicable to press also. And the press will be responsible while making publications, and that is very, very important. Similarly, the regulation of the press or regulating the press is a necessity because of a competing interest. On one side, there is a public interest. On the other side, there is a freedom of press. And neither of them can be compromised. And constantly, the press is trying to invade into the area of a public interest. Many occasions, the press is acting in such a way that it will compromise a public interest. Therefore, to protect the public interest, many regulatory mechanisms have been brought in, many laws have been made, subject to which only press has to function. I will give you a list later on. The newspaper has become a highly competitive business today. Hence, there are always an attempt to exceed the limitation of the free press and the right to have a free press. And therefore, a restraint becomes a necessity. And the self-regulatory regime does not appear to work when there is a race for survival, more money, more popularity, and the vice of overreaching a competitor in the marketplace. After all, press is an institution, and that such institution is manned by human beings. Human beings, what they are, who they are always trying to reach more. They are trying to do more than what they are limit of doing things. Mundane human activity. Therefore, there cannot be a mundane human activity on a self-imposed code of conduct of the right and wrong, to do and not to do, etc. Whether press can be left like that, freedom of press and freedom of speech of human being also is subject to a regulatory mechanism of the Constitution, Article 19(2), which I will read later on. Self-regulatory conduct had failed even in the theocratic and religious institution. Therefore, the press cannot be left of a self-regulatory regime. Therefore, many laws have been made. And to be very careful, when laws are made to regulate the press, such a regulation shall not invade the freedom of press. It's a very delicate balance of public interest on one hand, on the other hand, the freedom of press, which is inseparable from democracy and well-being, a human mind and a healthy human mind development is freedom of press is necessary. Therefore, at this juncture, it should be borne in mind, and press is also liable to be regulated, but not left absolutely free. It is often said, absolute power corrupts absolutely. Corruption, not necessarily monetary corruption, mental corruption as well, moral corruption as well, corruption of integrity. And all these things will come within the meaning of corruption. Therefore, nobody can have an absolute power. Neither the state can have an absolute power, absolute right of freedom of administration, nor the press can have absolute right of freedom of expression. Hence, the need for external prescription of allowable, permissible limit of conduct and freedom of activities. Consequently, several regulatory measures have been brought in to codify the extent of freedom of the press, extent to the freedom of the press. And the press shall be answerable for the wrong done by them or contravention of any law for the time being in force. Press should not transgress the Lakshman Rekha. And it should be borne in mind as on date. It should be borne in mind as on date. There are as many as 17 statutes, regulating the press. And there are so many laws which the field today. And I may not be able to give you the entire list of the laws. There are several laws, including the Press Council Act, and so many laws are there. And as I could count, there are 17 laws relating to the press, apart from the rules framed under that. And all these laws, in different ways, trying to regulate, but not curtail or interfere with the freedom of the press. To give you a glimpse of the laws, there are about 17 acts relatable to press laws, more than 20 laws relating to media acts and rules, more than 53 telecommunication acts and regulations and rules are there. And today, the press has become a misnomer because the field is now being occupied in a larger extent by other media, which I will be dealing with a little later. So far we have been discussing about the freedom of press, the importance of the freedom of press, and the freedom of press and the human thought, all these things. Now, there is always an attempt to interfere with the freedom of press. And one such attempt came during emergency in India, which often people call it a black period, Indian constitutional history. The proclamation of emergency was declared. The first proclamation of emergency was declared on 3/12/1971, when Pak aggression took place. When this emergency was still in force, a second emergency proclamation of emergency was made under the Article 352 on 26/6/1975. 26th June 1975, which continued up to March 1977. And during this emergency, first emergency is an account of the external war, aggression, and the second emergency is on the basis of internal disturbances. An account of the second emergency declared in Article 352 of the Constitution of India, and many declarations have been made, and Article 358 and 359 orders were issued by the President, making very serious inroad into the freedom of people. And several constitutional amendments were also brought in. Article 38, Amendment Act 38, 39, 40, 41, 42, and 43 were made. Altogether, during emergency, there were 5 amendments. Article 38 dealt with that the emergency declaration, ordinance, and promulgation of emergency shall not be called in question in a court of law. Under Article 352, 356, 359, and 360 shall not be called in question Part 3 or any other provisions of the Constitution. The satisfaction of the President as to the requirement of declaration of emergency under Article 352 shall be final and binding and shall not be judicially scrutinized. Similarly, 39 was made whereunder the President, Vice President, and Prime Minister office are protected and cannot be called in question. And 40 was several acts have been introduced by Constitutional 40th Amendment Act to be in the 9th schedule. Several acts have been included in the 9th schedule to keep them out of the judicial scrutiny. Article 42, Amendment 42, several amendments, including the amendments of the constitutions, enlarged the power of the amendment power and which cannot be called in questions. And several activities included and which are new articles 32A, 131A, and several other new articles have been included in the Constitution. So ultimately what happened was the freedom of an individual has been very seriously eroded, put outside the judicial review. One such case came to the Supreme Court that is very common to all lawyers. ADM Jabalpur versus Madhya Pradesh was brought and came before a constitution bench of 5 judges. 4 judges upheld the provisions of the law amendment, and H.R. Khanna and one of the judges in the constitution bench delivered a dissenting judgment and holding that Article 21 is not the only provisions whereunder the right to life, natural right, and such a right cannot be invaded even during emergency. That was his decision. Ultimately, after the emergency was over, the Janata government then passed 44th Amendment, which annulled almost all the amendments brought about during emergency. Especially, an amendment has been brought in making Article 20 and 21 outside the purview of even declaration of emergency. Even such a right cannot be invaded. Article 20 and Article 21 can never be placed outside the judicial review. That was one very important amendment which is brought by the Janata government, which still continues today. All these things one should understand is the basis of freedom of mind and freedom of thought. If there is no free expression of information, free expression of views and knowledge, free expression of administrative lapses, and exposition of wrong and corruption, the government shall not last long. One important factor which we have to learn from history is where the freedom of press is curtailed. I am referring to the USSR, Union of the Soviet Socialist Republic. Under its constitution, even though certain provisions said that you have a right speech, such rights are given only for the working class, such rights are given only to certain class of partymen, and such right is not given to the press. And the freedom of press was not there. Official newspaper like Pravada was the only newspaper available. Whatever the government information are made, that is published in newspapers. And what is happening inside the government is not known to the people at all. There is a lot of discontent. There are a lot of unhappiness throughout the society, maladministrations. And all these things, when it culminated in the fall of the Soviet Union and its constitution and breakaway of many of the states from the USSR, that had happened when Mikhail Gorbachev brought in two important ideas. One is a glasnost, another one was the perestroika. Perestroika is a reformation within the Communist Party, and a glasnost is openness and transparency. When glasnost was introduced by Mikhail Gorbachev in Soviet Union, and such a transparency brought in, and what is wrong with the hollowness of the society, the administration at that point of time, it virtually revolutionized the society, and it ultimately ended in the fracture of the communist government then, and then the constitution. Therefore, even today, there is a basis for that, because if any society which is closed and not available to the public information cannot last long, one day or other, people will have to protest against that. The government will fall. And the government without free press, there cannot be democracy. So without democracy, there cannot be a proper and useful government at all. And democracy is the essence of human life now. In spite of several defects, the democracy as we practice today may still have. Nevertheless, the free press is the integral part of democracy. That is why I said the free press is the fourth pillar of our Indian administration, of the government. The other, the executive, the legislative, the judiciary, and the fourth one is the free press. Free press is one of the very fundamental requirements of any free government and a transparent government. And that's why the Official Secrets Acts have been now repealed, and Right to Information Act has been brought in, so that all the governmental information shall be made available to the public. No secret and hush-hush administration can be done. This is the position of freedom of expression and freedom of speech and the freedom of press. At the outset, I would like to say, even though emergency had done a lot of damage to the independence of the judiciary, the independent mind of the Indian people at that point of time, and we have learned a good lesson. And we have now understood that the curtailment of the free press will not lead to any good government, will not lead to any good administration. That is why even today, and you find virtually the whole world is suffering under COVID-19. The government of India, government of the states are all trying their best to do what they can do to save the people, even at this hour. And the press is at galore, and they are discussing every threadbare, every aspect of this disease, every aspect of the amelioration measures that is being brought in by the government, and what are the suggestions the free people may give. All these things, every day you will find there is a great discussions going on, and the government has not interfered with that. So that is absolutely necessary for a proper administration, a free expression, free view, and free dissemination of knowledge. So far as India is concerned, when did the press came in India? Interesting information is available. The art of printing entered India through Goa, and which is made known in a letter Saint Ignatius of Loyola in 34-1556. 34-1556. Father Gaspar Coliza speaks of a ship carrying a printing press and setting sail from Albania, from Portugal to help missionary work in Goa. So, as early as 1556, the press has made some entry into Goa. The first printing press came to Bombay in 1670. The first printing press came to Bombay in 1670. First newspaper in India was published on 29/1/80, and which is called Hickey's Bengal Gazette. Hickey's Bengal Gazette was first published on 29/1/1780 and is otherwise also known as first English newspaper, also known as a Calcutta General Advertiser. Calcutta General Advertiser. First, the Hindu paper in Tamil Nadu was started in 1861 by G.Masilamani Ayya. That was in 1861. It started as a weekly. And from 1878, it has become a daily. Similarly, Sudesamicharan, a Tamil newspaper, was also published by G.Masilamani Ayya. That came into existence in 1882, and Sudesamicharan continued till 1985, almost a century. It went on 1882 to 1995. The first edition of Times of India, was published in India in 1861 and started first newspaper Bombay Samachar in Gujarati was started on 1/6/1822. The Mail, many of you may not know, the Mail that is called a Madras Mail or the Mail, there is a building you will find next to PR and Sons or next to Hindu office in Mount Road. There is an old building is still there and carrying the name the Madras Mail. The Madras Mail, or originally it was called The Mail, that was an evening English newspaper which was started in 1868, and it became renamed as Madras Mail in 1928. And the newspaper, there are several newspapers in India today, and when India became independent, there were about only 200 newspapers in India, registered newspapers in India. Today, the newspapers today is more than 1 lakh. To be accurate, 1,54,043. 1,54,043. You know, the revenue that is generated from the newspapers are 290 billion rupees a year. 290 billion rupees a year. The revenue is generated through the newspaper, which include daily newspapers and other monthly, weekly newspapers also. And it would be relevant to mention here, around 80 years ago, our former Chief Minister, Kalaiyan Karunanidhi, started a handwritten copy of a newspaper about 80 years ago. That was on 10/8/1942. 10/8/1942. Long before independence, when he was in teens, very interestingly, and he is a poor person as he was then he has a lot of interest, and he started a handwritten manuscript newspaper as early as 10/8/1942, and he was actually 17 or 18 years of age, under the pen name called Charan, and he wrote a manuscript newspaper, and which ultimately ended up as Morosali, and it is being published today very regularly. It has got a large circulation of 70,000 newspapers today. So it very clear to know that the interest-free mind requires a newspaper for knowledge and information. And this is one aspect which we may know. The next one I would like to share with you my own view, apart from these informations which I try to place before you. What is the media today? I should acknowledge with the folded hands the contribution of the free press for the independence of India, of a free India after independence, and the contribution of the various newspapers in India is no less important than the government which built the edifice of India today. And we cannot underestimate the contribution of the press, free press. And the knowledge, information, and the control and the governance of the state has been greatly helped and greatly advanced by the Indian press. There are so many newspapers in India, and all those newspapers put together have contributed a great length, and each citizen of India is duty bound to appreciate them and also salute the whole institution of the free Indian newspapers. Yes, of course. But however, it should be borne in mind today, where the press is without any malice. Today, the press is now suffering from a lot of malice. And therefore, it becomes necessary to give our free thought as to what should be done. And you have come up, and every day we are coming across biased news, false news, exaggerated news, cash for news, sensationalizing news, and at the same time transgressing the boundaries of the law, and at the same time transgressing the individual rights on two areas, on right of privacy and right of integrity, in other words, a defamatory area. And many papers take their own right to deal with other human beings' life and liberty, and they publish with absolute immunity and many informations which are neither true nor correct. So this one thing, how to correct? Whether the self-imposed conduct of the press can regulate this. There is an act called the Press Council of India, and the Press Council of India has got, like our Advocate Association, our Bar Council has got a council of its own, and it has got section 14 of the Press Council Act, which has neither teeth nor nails, and it can only admonish a wrong paper. It can't do anything else. And such a Press Council of India, it promotes the interest of the free press, yes. But it should also promote the interest of public interest, the interest and protections of the individual rights. How could they bring to book the wrongdoers, which they are not able to do today? And most of the information which is found to be wrong, and it is not possible to fight every individual to go to a court of law and fight the mighty press today. Very difficult to fight a press. And most of the people are afraid of fighting a press. Therefore, they want ignorance. This is one area the press has to think for themselves, and the laws as are now available doesn't appear to be sufficient to deal with the situations. I do not recommend a drastic law which will encroach upon and undermine the freedom of press. Freedom of press should not be undermined. At the same time, the freedom of press shall not be abused and misused by the press institutions to encroach upon the rights of others. One other area that is also occupying my mind is the basic concept of sub judice has now been totally cast away to the winds. You all know the concept of sub judice. When the court is now concerned with any dispute pending before a court, or it is being heard by a court, and no person shall comment on that. Any public comment on the litigation pending before a court or litigation under active hearing before a court is likely to influence and undermine the independence of the judiciary. Therefore, the concept of sub judice developed, and it was being fought for time after independence. Now, after the media has come in a long way, I'm talking about the media, not just a press media. Press would today include all other medias as well. Press includes today all other medias today, and which is much larger and much more pervasive than the press. I'm talking about the media means not just audio media like radio, FM radios, video, and your TVs, Facebook, Twitter, WhatsApp, and so many other new things have come. And all these things are every day constantly bombarding the people. To different sections of society. And how far these medias are under control, and it becomes very difficult. I earlier part of my submissions stated that the press shall not be pre-censored. Press can only be post-censored. Press can only be post-judicially considered or subject to judicial scrutiny of wrong done. And to my knowledge, I have not come across, except during emergency, any court interfering with the publication of any newspaper and stopping it. Only one incident, if I remember correct, T.N. Session published a book. And in that book, he made some scathing attack against the MGR. And that he gave those books for a preview for some people, and that came to light. And someone filed a case before the Madras High Court, if I remember correct. And matter came up before Mr. Justice K. Ramamurthy, who later appointed Madras High Court, thereafter transferred to Delhi High Court. And he considered that case, he is the first person or the only person or the first case where interim mandatory injunction was granted. Interim mandatory injunction was granted, directing Mr. Session not to publish the book with those offensive materials. Either you not publish the books, if you have already distributed books, withdraw those books, and these materials shall not be included in the book till such time the court scrutinizes that and then come to the conclusion. The reason is when a scathing remarks are made against an individual and is not subject to censorship of review, and the information is disseminated all over, and to what extent, to what level it has disseminated, nobody can fathom it. In such a situation, at a later point of time, it would not be possible to undo the mischief done. This is with a reference to a press, a book. But how about today's media? Today's media, I don't know most of you know, today digital signals travel at 3 lakh kilometers speed per second. I repeat, the digital signals travel 3 meter per second speed. Any part of the globe can be reached instantaneously. The speed is as good as that of a light. The speed of a light, the digital signals are traveling today. So once in that speed, if informations are disseminated and then lodged somewhere, how to dislodge them? It will be impossible. Therefore, it becomes necessary. One will have to ponder over whether the press today, free press today, is acting fairly and justly. Of course, substantial 90% of the press, 90% of the material may be not objectionable. Even 10% is objectionable. As it is always said, one drop of poison will spoil the whole lot. So even one person is affected. And then it cannot be undone. It cannot be cured. So this area will have to be given more thought. One area of sub judice, because today what's happening, every newspaper, every media is simultaneously discussing what is happening in a court, what is being argued, and that is being reported. And every judge, it is said, an English judge is not provided with a newspaper. An English judge is not supposed to read a newspaper. Because if he reads a newspaper, his mind becomes clouded, his mind becomes prejudiced, mind get preconceived notions. So that keep the mind of the judge free from any impact of external events. They were not given newspapers. Today it is not possible. Nobody is being attacked all around, bombarded by news information. If you open the mobile phone, a lot of information are coming. Whether you want it or you don't want it, it's coming. Similarly, the simultaneous trial, in other words, the media trial is taking place simultaneously along with the judicial trial, which is often interfering with the judicial mind. It often interfering with the judicial verdict. If I say often, I say it is likely. I do not want to import anything on the judiciary as such, but it can and it will. Because after all, the judiciary is made up of human minds. And another thing, what's happening today, under the freedom of press, when the case is being discussed in a court of law, the judge is expected to discuss with the lawyer at the bar with a free mind. He is bound to pose questions to the lawyers. Lawyers are bound to answer them. Judges may also express their mind at that point of time. I feel this way. What do you say for that? Is it correct to say that? Is it wrong to say that? So many a time the judges express their mind to elicit the view and argument of a lawyer. That is not the ultimate conclusion of the judge. But many of the newspapers are following the actual hearing of a case. Evening they report the newspaper, morning they report newspaper. This is what said by the judge at one part of the hearing. Ultimately, the ultimate result of the verdict may be different, and the people likely to mistake it. What is this? Judge said one thing yesterday, the judge is saying something today. So this area, how far the press is entitled to publish the hearing materials of the case, that it is likely to prejudice the mind of the people at large, and it may even undermine the confidence of the people in the ultimate verdict. Because the discussion earlier point of time was different. The ultimate decision is different. So therefore the people may think what happened in between. So therefore there is an area where the press has to be very, very careful in reporting as to what is transpiring in a court of law during the discussion. If that is not being done, it may ultimately result the judge not opening his mouth, not discussing it. If judge do not discuss, if the judge do not open up his mind, it will not be possible for any lawyer to argue and present a case and clarify any point. So therefore, this is one area during the course of hearing, course of a trial, what the judge says, how far it could be reported and how it should be reported has to be seen once again. Similarly, the sub judice, media trial, simultaneous media trial, and simultaneous discussions in the media along with the court, and that is also creating a great lot of problem to the judicial exercise. And these two areas will have to be understood. And the third one is whenever the press is invading into the rights of individuals. In a case of defamation, or in a case of privacy, to how far the remedy today available after the event have taken place. The exercise done by the judiciary, either to criminal offense or to get them damages, compensation, how far it will be sufficient, how far it will be protective. These two areas will also have to be seen. The Press Council of India Act perhaps needs an amendment and providing more power to the Press Council of India so that the press can be controlled by themselves from in-house controlling mechanism rather than throwing the mechanism to an outside agency, and which will definitely make some inroad into the freedom of press. This is one area which I would like to place my mind on the subject. With this, I conclude my inaugural lecture on the freedom of press, and I wish the organizers every success in the future meetings to happen. I thank all the viewers having listened to me very patiently. Now you cannot but do that. Thank you very much. Very kind of you. Jai Hind.
Respected judges, seniors, colleagues and friends, take this opportunity on behalf of JR Advocate Office to thank our senior advocate, Mr. Masilamani sir, for his mind-blowing lecture on freedom of press. Thank you so much, sir. I also thank all the participants for their support and cooperation. Thank you. I also request, there's one more request I'm wishing to place before this audience here. Yet another scintillating speech by senior advocate Mr. Kapil Sibil tomorrow at 11:30 a.m. I shall share the invite and the link. Please do join. Thank you so much. Thank you once again, sir, for helping us to make this event, and thank you very much for giving this mind-blowing lecture, sir. Thank you, sir.
Thank you. Thank you.
Sir, this is some that is you mentioned about session case that is actually that is late Anna Arranjar Anna case, I think, because of the book about Anna related some connection with the CAA. That is why the DMK and ADMK both parties objected. Then immediately that case also filed. There is not an FGR, sir. Can you check that?
I don't know. I really wanted to verify the subject because at the bar I remember I verified with Justice K. Ramurthy yesterday. I called him over the phone. I said whether it was an Anna or MGR. He said it was MGR. I'm not very clear about it.
Involved that case. That's why I remember that matter.
Then you should be correct.
Yeah,
both myself and
I met Session and everyone about to get a letter from Session about to some apology for to mention about Anna name and other thing. In 1996, that is he written a book about his lifestyle and life history. Because of after retirement, he's published that book. There is a big galata going on. Even when he was in Chennai in Taj Coromandel, at the time that the chief minister that, Jayalalitha was the chief minister. She made some party galata and other thing. Then after that, I personally met the station. Station given a letter. They published in the newspaper also.
Very good. My reference to that was about the interim mandatory injunction.
Okay.
Whether the court can give mandatory injunction like a censorship of the government. So the concept is interim mandatory injunctions of even before the publication. That's a very rare case. That never happens.
Okay.
Thanks for the information.
Thank you.
Thank you very
Wonderful
much.
speech. You've given a lot of reference as editor of the Satta Kadir. I'm giving. You are told about for the all the press issues and problems and also the present situation. A lot of people facing issues. That's all you addressed very well. It's a very useful speech to publish in the newspaper, as well as we can publish even Satta Kadir translated in Tamil. Thank you, sir. Thank you.
Thank you, sir. Thank you very much. Thank you, all of you all. Thanks a lot for making this event a grand success. Thank you.
Hope